Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3033 et al. United States of America versus Gerald Smith, appellant. Mr. Smith for the appellant, Mr. McGovern for the appellate.
Good morning. May it please the court. My name is Greg Smith. I'm appointed counsel for Gerald Smith. And we're here because the district court erred in denying in part Mr. Smith's 2255 petition and all of his Fair Sentencing Act motion. On his 2255 petition, Mr. Smith was given leave by this court to file Johnson challenges to his 924C sentences, or convictions, excuse me, because 924C's residual clause had been stricken, raising questions if the predicate offenses still were crimes of violence. The 2255 was granted, striking his 924C that was based on kidnapping, but the 924 based on CCM was upheld. We appealed, and now the government, for the first time, says this court need not even address these issues on the merits. You know, I often tell my kids, when you're facing huge, even seemingly overwhelming tasks, sometimes you just got to chip away one piece at a time. And that's Mr. Smith's task here. He must do that, or else he will die in prison for acts he committed at age 17 to 21, over 30 years ago. The system already has plenty of procedural bars in place already. He's overcome all of them just to get here. He had to convince this court before he could file successive habeas. The government didn't raise the concurrent sentencing doctrine then. It was then filed in district court and sat there for years. Again, the government didn't raise it then. The CCE murder issue was then extensively briefed in the district court. The government didn't raise it then either. In fact, the government told the district court that it could grant 924 relief on the kidnapping count, where the kidnapping predicate was in play. That is inconsistent with its argument here. We then timely filed an appeal to this court on the rest, the CCM murder predicate, and the government filed no motion to dismiss. I then extensively briefed it here, and only when the risk became apparent that they might lose on the merits did the government belatedly raise this issue of concurrent sentencing doctrine. Well, the concurrent sentencing doctrine doesn't fit here anyway. This isn't a challenge to a sentence, but to a conviction. This also isn't a concurrent sentence. The government brief references concurrent life sentences, but they are not concurrent life sentences. The 924Cs are consecutive to those life sentences. So it's not a sentencing issue. These are not concurrent sentences, but the government is arguing
that amounts to the same thing, doesn't it?
I'm sorry?
That amounts to the same thing. A consecutive life sentence and a concurrent life sentence are equal, aren't they? How can you have two lives?
You have the 924C, which is consecutive, specifically by statute consecutive to any other sentence. So it is expressly made consecutive to the life sentences.
Yeah. Doesn't answer my question, but go on.
I'm not arguing that the life sentences are consecutive to each other, Judge Randolph. I'm arguing that the 924C, the one that's an issue here, is consecutive. That's the one that we're trying to.
You're also arguing, I take it, that the government waived the concurrent sentence doctrine?
Yes,
Yeah.
I am.
Are you familiar with our case, United States versus Price, 938 Fed Second 1343?
I don't know it off the top of my head, Your Honor.
It's a case in which the government, not only in the district court, but also in the Court of Appeals, failed to raise the harmless error doctrine, concurrent sentences, an offshoot of that. And we held that we have the authority and did to decide that issue sua sponte. Seems to me your argument contradicts United States versus Price.
Well, Your Honor, that's not a case that was raised by the government, and in
If they
opposition,
don't
I
raise a
was,
case, have they waived that too?
no, Your Honor, I would
There's a
not.
Supreme Court decision saying no.
No, I would not argue that. All right, well,
The
let's
point of the concurrent sentence doctrine is to save courts time
understand.
addressing issues, but of course, no time was saved, the district court, because it wasn't raised before the district court.
This could
It's
have,
been fully briefed here, so there's, even if it were preserved,
yes.
is there
So,
any function to the concurrent sentence doctrine in this court, which this court has not yet adopted?
yes, Your Honor, I would argue that
Saving any time, right?
it's not saving time. We went all the way through the district court, and now
Saving resources.
it's increased resources.
Now we're spending.
Exactly. We're not only dealing with the 924C, we're also dealing with the concurrent sentencing doctrine and how far it extends.
Did you?
I will. Let me first, though, say just that, please look at, I'm sure you have, at Judge Wood's dissent, where she cogently explained that due process shows that a conviction of a non-crime is always prejudicial error as a matter of law, and it's always by definition harmful. Turning to the 924C charge itself, these 924C charges must necessarily rise or fall based on whether CCM is categorically a crime of violence. It fails to meet that because the elements and force clause has not been satisfied. It lacks the necessary mens rea because it requires intentionally kills, comma, or counsels or causes a killing.
Can I ask you a question?
Sure.
It seems to me that the CCE murder elements are that there has to be intentionally kills or counsels, commands, induces, procures, or causes the intentional killing, and such killing results. It seems like an element of this, any way you slice it, is an intentional killing. An intentional meets the mens rea requirement. And it seems that you're arguing that this mens rea must be attributed to the defendant. But in the actus reus context, the actus reus doesn't have to be attributable to the defendant. Why does it have to be attributable to the defendant?
Well,
On mens rea?
I would agree that intentionally meets the definition, but intentionally modifies kills, intentionally kills.
No, but in the second thing, there still has to be an intentional killing that results.
Merely has to cause.
I think you're focusing on what the defendant has done. I'm saying that this offense requires an intentional killing under either clause. This intentional killing might be committed by somebody else with the requisite mens rea. But I'm saying, why do we have to attribute the requisite mens rea to the defendant as opposed to whoever commits the intentional killing
Because
that's listed in the offense?
it's the
In
line.
the actus reus context, it doesn't have to be the defendant. It could be anybody.
Yes, but 924C is specific to the defendant. And 924C, recklessness is not enough. And
I'm
And
asking
so
a different question.
I understand what you're saying, I think, which is what I'm trying to say is that recklessly causing an intentional killing by someone else doesn't qualify because the intent, the mens rea that applies to my client, the recklessness issue. And when you're looking at whether he can get hit with a huge mandatory consecutive term on top of that, 924C says you have to look at the intent of the mens rea elements, and my client can be.
Could I ask? Just raise element, because there's case law that says the actus reus can be attributed to a different person, the actual killing. Like, it doesn't have to be the defendant. So why does the mens rea have to be attributed to the defendant if the actus reus doesn't?
It's derivative mens rea that you're trying to attribute to my client. And I don't think in an aiding and abetting context, the aiding and abetting has to meet a certain threshold. They don't use the aiding and abetting language here. And so the recklessness is the only mens rea. I mean, mens rea is whether someone has committed wrong. Someone has intentionally committed a crime. It's the essence of a crime.
But
And-
actus reus is an important part of the crime. So can you just explain why I should treat mens rea differently from actus reus? Its seriousness, or why one could be attributed to other people, but the other cannot.
I think because in the context of conspiracies, for example, acts done by others can be attributed to you, but you have to look at the person's individualized intent. Did they intentionally join the conspiracy? And we don't have that intentionality here. What we have is, I mean, merely recklessly causing an intentional killing or a killing where the killing results. The only mens rea, which is the essence when we're looking at individualized wrongdoing, the only mens rea that is being applied to my client in an act, the acts can be attributed, but intent is never attributed. In a conspiracy case, just because somebody else had the intention to join the conspiracy, that doesn't make them guilty because they have to intentionally join the conspiracy. You always look at mens rea differently in the sense that the defendant has to have individualized wrongdoing, and individualized mental, purposeful or reckless, depending on what the standard is, a reason to make them harmful, not for the acts of others. They can be held liable for the acts of others under certain circumstances, but the essence of what makes it a wrong, what makes it a crime, is what's the mental state. That's why we have insanity laws. The mental state is different than the acts because we have to look specifically at the individualized mental state of someone, regardless of whether the acts might be attributed to. I understand I'm past time, but let me just briefly say in concluding, well, because I don't want to leave this, on the Fair Sentencing Act, we would argue it's an abuse of discretion to leave in place a sentence that is above the statutory maximum. At a minimum, the district court needed to explain why, under the White case, why she was leaving in place a sentence that was not only severe, but higher than what society accepts it today as a possible sentence.
The law is clear that the district court may adjust the sentence. It doesn't say must.
I understand.
So I'm trying to get, and given, been told a very broad discretion of the district court and a light touch appellate review of these decisions. That's what the Supreme Court said. And so how do we get from that to they have to adjust some sentences, at least under the circumstance where it's no longer a lawful sentence?
Yes, Your Honor. I think the White case does say that despite the broad discretion, it's not unbridled discretion.
Well, unbridled just means you can't abuse discretion, but,
Yeah.
but you need to make an argument that as a matter of law. So as a matter of law, it's always an abuse of discretion. Is that your view, to not adjust a sentence that where the law now prescribes a lower sentence?
If she'd given 40 years, I may disagree with that sentence, but yes, I think when it's beyond what society, the whole purpose of the Fair Sentencing Act was to normalize, to make consistent pre and post Fair Sentencing Act sentences. And for her to leave in place a sentence that society no longer accepts today as tolerable. I think at least in that limited circumstance, at a minimum, she had to do more than she did. What she said in part was it would be an advisory decision, which is simply wrong. It would not be an advisory decision to change the sentence on that count. And most importantly, this must be decided now. If this is not decided when we raise this under the Fair Sentencing Act, if it is not addressed, he will lose the ability to raise this forever. So even if in the future, all his other sentences in the life sentence.
Was that true? She did she called this being an advisory decision. So that it's almost like it wasn't before her to decide, because federal courts don't do advisory opinions. And so it's not going to change anything. The court's not going to do anything. The bar on raising a request for adjustment at a later time only applies if the original claim was fully heard on the merits. And if she, at least partially, did not decide it on the merits because of a sort of procedural barrier, in her view, the advisory opinion nature of it, then perhaps you didn't have it fully addressed on the merits and would be able to raise it again later.
She did look at the merits. And I'm sure later on they will argue it.
Yeah, the government are going to disagree lots of times. So my
Right.
question is, do you understand what the district court did here to be full consideration on the merits or not, given her concerns about issuing an advisory opinion?
Think will face procedural bar challenges down the road that he doesn't deserve.
People raise challenges that are wrong all the time. I'm asking you your opinion of whether what happened here, in your opinion, satisfies that statutory requirement of full consideration on the merits that would bar a later claim, or are you arguing that it's a concern, but in fact, you would have a good argument later that in fact, there was no full consideration on the merits because of her concerns about even, her decision to back off from issuing an advisory opinion?
The short answer is I don't know. And even if I did know, my client would be faced with a procedural bar that he doesn't deserve. He raised this timely. The statute says it's supposed to be heard on merits, and he shouldn't face a procedural bar later when he doesn't deserve it. He raised it timely, and if it doesn't get decided, he's going to be faced with an additional procedural bar down the road that he doesn't deserve as he tries to chip away at his sentence.
I'd like to go back for a moment to the issue of mens rea and the second part of the definition of a CCE murder. I understand your argument to rely on cause, and that cause can be, that's one way of proving CCE murder, causing the killing, and that can be reckless or negligent, something short of intentional. And I'm wondering if viewing cause in the context in which it's raised in this definition, that cause could be viewed as somewhat ambiguous because it's in a list of other words that are intentional, like counsel, command, induce, procure. And we have case law that says that, this is the Morgan case, that says if there's a general scienter provision, the presumption applies with equal or greater force to the scope of that provision and others. And if cause is viewed as somewhat ambiguous in this context, under the nocitur a sociis canon, we would want to view it like the other words in the list, which are all intentional. And I'm just wondering what your view is of how we should view cause if we think it's ambiguous in this context.
Two things. One is we did discuss the Morgan case in the reply, but more specifically, if it is ambiguous, then under the rule of lenity, then my client needs to be given the benefit of the doubt. If it's ambiguous, then it should be resolved in his favor. Because if there is statutory ambiguity, he's not supposed to languish in prison based on ambiguity in a statute. That's what the rule of lenity is all about. And we did raise that, and the government didn't address the rule of lenity.
Thank you very much.
Good morning, Your Honors, and may it please the court, Michael McGovern on behalf of Appellee, the United States. This court should affirm the district court's partial denial of Mr. Smith's 2255 motion because it correctly found that CCE murder is a proper predicate for a 924C claim or conviction. Additionally, the district court did not abuse its discretion in addressing Mr. Smith's First Step Act motion when it found that he was convicted of covered crimes that would permit him in its discretion to give a sentence reduction, but then exercised its discretion not to provide the requested reduction. Turning first to CCE murder as a proper predicate, CCE murder is a proper predicate for a 924C claim for two reasons. It is both a crime of violence and it is a drug trafficking crime. And as such, Mr. Smith was not entitled to vacation under 2255 of those convictions.
On the crime of violence, though, how do you grapple with the word cause? If we don't think that intentionally modifies cause can include reckless or negligent causation.
Yes, Your Honor. So specifically with respect to cause, our first point is that the word intentionally, which comes before kill, is not limited to the verb kill. There's no reason to limit that adverb only to the verb kill, but would then extend to all of the verbs in the list, which I refer to as the aiding and abetting clause, which comes after the kills. And so in that way, intentionally would modify cause. Even if this court were to question whether it intentionally should be read to cause, we would turn to, as Your Honor cited, this court's decision in Morgan, which says that where there is a missing scienter requirement, this court will read one in, and if there is a scienter requirement that is explicitly stated in the statute, that should be applied to all of the elements that require a scienter requirement. And here, that scienter requirement would be intentionally.
Your submission is that use of intentionally is necessarily use of force?
To intentionally cause an intentional killing would necessarily be a use of force against an individual. Yes, Your Honor.
Okay. What about poison?
Yes, Your Honor. We believe that in the context of...
That doesn't involve use of force necessarily at all.
Well, Your Honor, the Supreme Court in Castleman grappled with that and indicated that use of force doesn't necessarily mean use of direct force. The force doesn't have to be directly applied. And that poison, under the common law understanding of what use of force means, even using poison to cause injury would be a use of force. And so under that understanding of force, that force can be indirect. In the same way, Castleman points to when one pulls a trigger, pulling the trigger is not using force against someone, but shooting someone is a use. The force that is causing the injury may be the bullet, but the individual pulling a trigger is using that force against someone. Similarly, when someone sprinkles poison onto food, they are using the force against the individual.
It's a bit far-fetched, isn't it?
Well, I believe the Supreme Court specifically addressed it in Castleman, and so under that line of cases and the cases that have come out interpreting that in other circuits, it would not be far-fetched as a legal matter to say that the use of poison was a use of force against an individual where it caused death, as is required under the CCE statute.
What if I'm the right-hand person to the mob boss? The mob boss is extremely old and bedridden and in frail health, has to have medicine each day or will die. Heart issues or whatever, will die without that medicine. One of the things I do is give the mob boss that medicine each day. And one day, intending that he die, I do not give him his medicine. And nature takes its course, and he dies exactly as I intended. I've intended the killing.
Yes, Your Honor.
Intentional killing has resulted. What force have I applied to his body? I let
So-
nature take its course.
That's answered by the Sixth Circuit. This is a question of whether an omission can count as the use of force. And in Harrison, the Sixth Circuit said yes, where an omission causes injury and you intentionally omit the action in order to cause that injury, you are, in a legal sense.
You have someone in a situation, you've got someone locked in a room, or it's a dependent child that you don't feed. I'm talking about another adult here who's not trapped, who's not locked in, who has other people coming and going. But everyone knows I'm the one that gives them the medicine and no one assumes otherwise. You have to show that categorically the statute requires the use of force to be applied directly or indirectly. What force have I applied to the body when I just let this natural bodily condition take its course?
Well, again, I'll point to the Supreme Court precedent in Johnson, which was the subject of Scalia's concurrence in Castleman, specifically finds that, and this is a quote from page 173 of that concurrence, which is quoting from Johnson. Johnson is significant here because it concluded that, quote, the phrase physical force means violent force, that is, force capable of causing physical pain or injury to another person. And later on, he goes on to say, since, and this is a quote, since it is impossible to cause bodily injury without using force capable of producing that result, any causing of injury.
An example where whatsoever is applied.
But in the comment,
you can point to me, what is the force that I have applied in my hypothetical? What force?
The omission is considered by the law as a legal fiction to be
required.
But there are forces at play, Your Honor, and they're natural forces, as you indicated.
Government's position that if someone dies of natural causes, if I sit here and intend they die of natural causes,
if an individual has the ability to prevent those natural causes from,
if I see somebody drowning, walk by someone who is drowning, and I sit back and I go, oh, that's that person I don't like. Intend that they die from drowning. And I just don't do anything. I don't jump in the water to save them. I have committed an intentional killing. You're turning tort law quite upside down.
Well, if there is a legal obligation to act, yes.
The law requires to give
where an individual is omitting to act and they intend
act.
Under the precedents of the sister circuits, they have looked at whether or not an omission which is of a type that causes substantial physical harm.
Legal obligation to act.
Your Honor, I don't know that I can speak directly.
An omission, even with no legal obligation to act, constitutes the application of force for purposes of the actus reus here?
In that, as a categorical approach to CCE murder, where one is intending their omission, yes, Your Honor. But even if
that's really, wow, okay.
But
so we all have, if we see someone we really dislike and that we really would love to see die, and I know they're going to die,
there was,
and I do nothing to get them out.
But there was the addition of this individual is preventing medication from getting to this other individual. The manner in which,
excuse me, I haven't said he hasn't locked the medicine up, or anyone else can give him medicine. The guy just has to ask, but nobody does. He doesn't ask because his assumption is this guy's going to give it to me.
Again, where they are their omission is becoming an affirmative act in that circumstance, an affirmative act that is causing harm that they intend to cause. And in that circumstance, they are, we believe, under the doctrines, using physical force. But CCE murder is additionally a crime of violence, also qualifies as a drug trafficking crime and therefore is a valid predicate.
We can't possibly hold this up as a drug trafficking.
We believe you can, that the question of whether or not it's a drug trafficking crime. I'm sorry, Your Honor, we did not press this argument in the 2255 litigation. That is correct, but it's a question of law. They weren't asked to decide that it was a crime of violence. They were instructed that it was a crime of violence. So in the full context of what the jury instructions were given. I'm sorry, Your Honor?
Were they asked?
No, Your Honor, at the time, all of the parties agreed that that CCE murder was a crime of violence. And so that instruction, but in the jury verdict form, it was very clear that the government's position was that CCE murder was a drug trafficking crime. So
Or
that's how it was listed in the drug trafficking, in the jury verdict form. I'm sorry?
so how is that clear that that was the finding? They could have found the crime of violence.
Oh, I apologize. I don't believe that the jury was ever asked to make a specific finding that it was a drug trafficking crime, nor were they asked to make a specific finding that it was in fact a crime of violence. They were instructed that it was a crime of violence. In its totality, the jury instructions instructed the jury that they were to find whether or not this individual committed CCE murder, and were then instructed that CCE murder was a valid predicate for the 924C. So the factual questions that the jury was deciding was whether or not the individual CCE murders were committed. And so in that way, there's no apprendi issue with respect to the drug trafficking conviction. And because it is a question of law, drug trafficking, whether a crime is a drug trafficking crime, this court is not prevented from affirming on that basis, because its review of that would be de novo. And so although we didn't press it in the 2255 litigation, it doesn't prevent this court from affirming on that basis. But turning back to the CCE murder, unless your honors have further question, I would move on to the First Step Act if there are any questions on that issue.
Just take a couple minutes. You're over your time here, but go ahead and take a couple minutes on First.
I would be happy to answer questions. I think our position, as we indicated, is that the trial court did correctly determine that only 2 of the convictions were even covered offenses that would permit resentencing under the First Step Act, and that after correctly making that legal determination, it then exercised its discretion as it was required to, but determined not to, and that discretion should be deferred to here in this court.
How do you distinguish the Collington case from the Fourth Circuit, which said that whatever that discretion is, you can't leave in place a sentence that is in excess of what the law now allows?
So I would first note that Collington was decided before Concepcion, before the Supreme Court sort of full-throatedly said there is no obligation, the statute does not require one, to reduce any sentence, even where there's a covered sentence. But I'd also note that the Fourth Circuit itself has recognized that Collington seems to be in tension with Concepcion. And so I would note—
The published opinion, that's the problem.
There was a published opinion, and it's not cited in our brief, where they stepped away and noted that Concepcion was decided after Collington. And I apologize that is not cited in our brief, but the Fourth Circuit has recognized.
So Concepcion, in a published opinion, they've now—
Correct, Your Honor. And I apologize for not having that citation for you at this moment. But we would argue that the Fourth Circuit's analysis falls apart after Concepcion there.
Maybe you could send that citation.
Yes, Your Honor. If there are no further questions, we would ask that the judgments be affirmed.
Thank you very much. Mr. Smith, we'll give you 2 minutes on rebuttal.
Just very briefly. Getting criminal adjudications right is maybe the highest, most solemn obligation of any court. That's why the government said it's no problem to remand to fix the judgment and commitment order here because it got 2 DC convictions wrong. They said you can go ahead and remand it to fix that, even though it won't affect the aggregate sentence, even though it won't affect the aggregate sentence, because it's the right thing to do, even when it has no effect on the aggregate overall sentence. Now you should also do the right thing on the rest and not leave these illegal convictions in place. The government agreed there that it was obvious we should send it back and fix it because it's important to get it right. But what it's telling you here is it's not really required if it will require you to do the hard work of deciding a legal issue of first impression. You should always try to, and you need to, your duty is to try to, the court's high solemn duty is to get convictions right and to strike convictions when they are not crimes. Our argument here is these 924C convictions are not crimes, and therefore this court must take it up, even if you agree with the collateral sentencing. They are not crimes because it's not a valid predicate. So it is a non-crime.
Is that it's an illegal sentence, but not that there weren't crimes.
The argument on the 924Cs, the 2255, is they are not crimes because they're not a valid predicate. And even if you were to find the concurrent sentencing doctrine appealing, this simply is not the case to do it. It was half of this motion was already decided. This is not the case for you to adopt the concurrent sentencing doctrine when half of the issue has already been taken up, and we're simply looking at the other half to try to get the rest adjudicated here, just as it was adjudicated below. The important thing is to get to the right place and to not uphold illegal convictions. And these 924Cs are illegal convictions. Whether, this is, cases are tough a lot of times in the criminal setting. You have to, you're not supposed to consider it, but in the back of your mind, you always know somebody may get immediately released to the street. This is not a case where anybody's going to get immediately released to the street, but we ask you to do the right thing, take these issues up and decide them, and to strike the convictions that are no longer valid after Johnson. Thank you.
Thank you very much. Mr. Smith, you were appointed by the court to represent Gerald Smith in this case. I'm very grateful for your assistance.
Thank you very much.
The case is submitted.
Case number 22-5341, Monte Silver and Monte Silver Limited Appellants versus Internal Revenue Service et al. Mr. Zell for the appellants, Mr. Rennie for the appellees.
Morning, Your Honors. Name's Mark Zell. I'm here for the appellants, Monte Silver and Monte Silver Limited. May it please the court. Your Honors, Monte Silver and his company sued the IRS in order to compel the IRS to comply with the Regulatory Flexibility Act of 1980 as amended in 1996. The IRS as even the Sixth Circuit and the Government Accountability Office has indicated, has consistently failed to comply with the requirements of that statute. The district court, in ruling that the Silver suit was barred by the Anti-Injunction Act, 26 USC 7421, failed to take any account of the congressional mandate regarding the proper balance to be achieved in RFA suits under the when an Anti-Injunction Act defense is raised. This case represents the first time in history that we can determine where any appellate court will have had the opportunity to address the interplay between the Anti-Injunction Act and the Regulatory Flexibility Act.
Before you do that, Mr. Silver's company, is the company itself a United States taxpayer?
The company itself is an Israeli limited company, limited liability company. It is wholly owned by Mr. Silver, who is a United States citizen.
I understand. Will the company itself ever have to pay this tax?
The company itself will not have to pay the tax
Ever?
ever. Okay, but the company, this case is not about the, excuse me, Your Honor. This case is not about the payment of the tax. This case is about the compliance.
The company, I'm not talking about Mr. Silver.
Okay,
If the company never, not even subject to this tax, then how can it, and it's not a United States corporation, how can it raise any challenge? Apart from, I'm not talking about Mr. Silver himself individually. I'm talking about this company.
the company and Mr. Silver, we've maintained in the previous litigation and in this litigation, which the district court agreed with, are to be considered as a single package or entity because they are the object.
Company not filed its own tax returns?
The company doesn't file U.S. tax returns, okay? Mr. Silver
Mr. Silver
files the tax returns and he made an election. He made an election under section 962 of the code.
No, I just don't understand why the company is even before. It's not a United States taxpayer. It's never, ever going to be subject to this tax.
That's the essence of this case, Your Honor, is not whether Mr. Silver, who has no tax liability, or the company who is not required to pay United States tax has any tax liability.
Company obligated to provide this information to the IRS? I get that Mr. Silver is.
The company cannot, Mr. Silver cannot apply
I understand Mr. Silver.
he can't give the information unless the company provides it. The company therefore provides and it incurs compliance costs for purposes of standing as a result of the regulations in this case. And therefore, the company is a proper plaintiff in this action. But the real core of this dispute, and while we're here today,
What happens to the company if it doesn't provide the information? The IRS has no jurisdiction over it, can't sanction it, can't do anything to it.
but the company has
This is too much of a burden. I don't want to do it.
the company has incurred costs, okay, as a result of the action by.
It's done that because it's helping out Mr. Silver. I guess that they're one of the,
Sir.
but just for our purposes, you brought us here as two plaintiffs. If this company chooses to do this paperwork to support Mr. Silver's needs, that's a choice. But there's no legal obligation. Mr. Silver has a legal obligation.
This is a one-member company, Your Honor.
Mhm.
Okay, Mr. Silver and the company are identical. Okay, they are one and the same.
Identical if one's a U.S. taxpayer, not. If
Oh,
one's
okay, but
excuse me, one's potentially subject to the tax, potentially may not have to pay anything, might come out as, but is at least subject to the tax, and one
What?
is not.
okay, why?
And one's a small business, and one is not.
Now we're getting into the statutory standing argument.
It's not a statutory standing argument.
Yeah.
Plain old standing argument.
Mr., and in Your Honor's opinion, who is not the small business? Mr. Silver, because he's an individual? Is that where Your Honor's
I'm asking
going?
you these questions.
Well, I'm saying Mr. Silver is a small business in our interpretation of the Small Business Act, Section 3, and for purposes of the Regulatory Flexibility Act, yes. That has not been determined by any court thus far.
What's your individual?
No, it says, the statutory language says, and I don't have it right in front of me, that to be a small business concern, it has to be independently owned and operated, and it has to not to have a significant role in its field of operation. That's the statute, the 1958 statute.
That apply to the company?
The company also meets that standard clearly. So in our view, there's no question about the standing of both parties and either one.
It may not be in your eyes, but I'm asking questions because there's some in mine. So if Mr. Silver is not individually, because you've got two plaintiffs here, two appellants, Mr.
Correct.
Silver and the company, separate ones. Mr. Silver does not seem to me to qualify as a small business.
I disagree.
Okay.
This court will be the first one in the nation to determine that issue, that whether an individual can qualify as a small business under Section 3 of the 1958 Act and the Regulatory Flexibility Act. Well,
You've got a business here that would, a corporation here, assume that qualifies as a small business, but it's not a United States citizen. It's not subject to this tax. And so I'm trying to figure out what to do.
we're not attacking the tax. We are attacking the impact of the regulations on these plaintiffs in terms of incurring compliance
Israeli
costs.
corporation, just the core Israeli corporation. No members are U.S. citizens. The corporation isn't a U.S. citizen.
This is a hypothetical?
Excuse me, has
Excuse me.
no business in the United States. They couldn't bring up a Regulatory Flexibility Act challenge to a tax that doesn't apply to them. So that's why I'm trying to get you to explain to me how this is working.
I'm trying to explain, Your Honor,
Okay?
that when a foreign CFC is wholly owned by a U.S. citizen, shareholder, 100%, and incurs and is the object of a tax along with the U.S. citizen. The citizen actually pays the tax, but he does so based on the profits and the economic and financial information accumulated at the company level. And the tax is directed, and when you read the regulations, in order for the U.S. citizen to file his tax return, his 899-2 or 5471, he needs to have that information from his wholly owned company. It's at that level that the profits and the guilty profits and all these various terms that are involved in this statute are computed, calculated. He then takes that information, which the company accumulates, pays for in part, gives it to him, and he files it on his U.S. tax returns.
So the burden that you talk about, how burdensome this information gathering process is a burden on this company.
It's a burden on both because they both incur compliance costs. Okay.
Well, you just described to me that the company gathers all this information, gives
Right.
it to him, then he files his tax return.
Right.
So his burden seems to be filing a tax return, which is not a relevant burden. And so the burden is collecting all the information, organizing and getting it together, and that's done by the corporation.
Well, the corporation has a significant burden, so does he. He hires his CPA or his tax preparer, or in his case, he's a tax attorney who spends the time necessary to put together the information that he gets from the company, puts it on his return, and he has compliance costs as well.
Well,
The two of them have compliance costs.
Compliance costs of any tax.
No,
Any
but
taxpayer has to get it, either do it on their own, that's their own compliance cost, or they get a tax preparer to take the information that they have and put together the tax return. But that's not what you're complaining about. The burden, as I understand it, is what the corporation is doing, gathering all this information about the foreign earnings and figuring out whether they're going to be how much it was and whether they're going to be subject to the tax.
the district court necessarily, the burden was shared by the two plaintiffs. The fact that the company has its own compliance costs in gathering all this information and putting it together, giving it to the taxpayer who then also for his purposes needs to go through that information, consult with the experts or whatever, put that onto the tax return, which he is required to file under the law. That is sufficient, as the district court found, to establish standing. Now, the real problem in this case, as I see it, Your Honor, and with all due respect, is the interplay between what the district court concluded regarding the Anti-Injunction Act and the RFA. This is the first time, as I said, that any court has considered this. And when you look at the literal language of the RFA itself, particularly its reference specifically to IRS interpretive rules and under Section 603, Section 604, later and also in the legislative history, a very impressive document called a Joint Manager's Statement of Legislative History and Congressional Intent, which both parties cite. You can see that with Congress, when it passed the RFA and amended it in 1996 to include judicial review for the first time because of the noncompliance of the IRS with the previous statute and the remedial provisions that are also set forth in Section 611. Congress specifically stated in unambiguous terms that how the Anti-Injunction Act and the RFA were to be accommodated in an RFA action. What they didn't do is what the government has taken the position below, and the court also agreed with the government on this, is to say that basically any time a taxpayer seeks to enforce the requirements of the RFA against the IRS. I see my time has expired. I don't want to.
Keep going.
Thank you.
I'm going to ask you something that
Please.
The statute, we call it the guilty statute, was passed, and the regulations took a while before they came out. They didn't come out till June 2019. So I think there was a tax year, 2018, where folks were subject to this tax, but did not yet have any regulatory guidance from the IRS. How did your client figure out whether he owed guilty tax? A bad word. GILTI tax, without these regulations? Is one as capable of figuring this out without the IRS regulation?
Difficult. Very difficult. That only underscores the importance of the.
Difficult with the IRS regulations?
No, they actually made it more so.
Okay. So your view is there's less burdensome. I mean, some taxes are just burdensome to deal with. But if there's a less, so for 2018, there, and not just this company or person, but it sounds like people all over the world would have had to pay this tax without any IRS guidance. IRS guidance is not essential to the payment of this tax.
No, the factoid that stands in my mind is that the regulations, which were first published in 2018, the preliminary regulations, and the final ones came out in 2019, as your Honor indicated. They were not to become, the final regulations were not to be effective until October, I believe, 2018. Okay, so what is that? 18. This is what it says.
Final regulations came out in June 2019.
So that's true, but I believe under 1.95A1, 951A-7, it says 2018. Don't hold me to it. Well, that's an interesting question. This is one of the points I think it needs to. Well, one of the things that he didn't have at the time he filed, he was required to file or pay the tax, if indeed he was the form that he had to file until the IRS actually passed the special regulation, which was part of the guilty regulations that were finalized in 2019, they didn't specify a form. There wasn't even
Forms seem to predate the regulation.
no, the form is 8992. And if your honor looks at the Federal Register provision, which published the final regulations in 2019, you'll see it's in the last 2 pages of the regulation. Most of the regulation has to do with all the defining of the terms and the ways of calculating the guilty tax. It's 340 pages, I think. And then the last 2 pages include the addition of the revision of one regulation and the addition of a brand new regulation, 1.6038-5, which is the first time the IRS specifies a form for actually submitting, calculating, and then later submitting the guilty tax. And that is part and parcel of the guilty regulations. And that really is the focus of the appellant's attack on in this case. The regulations that they're challenging are the reporting regulations, which is all, by the way, that the RFA really can deal with. And when the RFA was amended in '96, they introduced for the first time this requirement that the IRS must, before it publishes or publishes finally any interpretive regulation or rule like we're dealing with here, it must take into account the interests of small businesses. And what the IRS did in this case, as it did in every other case that it's dealt with in the past, is just to basically certify under 605B that it doesn't have any obligation to, because
you have argued that could defer enforcement of the regulation, even just remand for them to comply with the Regulatory Flexibility Act. If that were to happen,
Correct.
that would not change your client's legal obligation to pay the tax or determine if he has to pay a tax. And so he would do it how? Without the regulations? Or how would he figure it out?
all that needs,
It's really hard and complicated. How would he do it?
all that needs to happen for our purposes under the RFA is for this court to direct that the regulation in question, the reporting regulations, the information gathering regulations, be remanded to the agency. Now, there's a separate.
My question to you, I said you asked for that relief, but while that process is happening, let's just assume it's going to take a little time for the IRS to do it.
Sure.
The legal obligation to pay the tax remains unaffected.
Correct.
And so without that guidance and those forms, how will your client figure out? Will your client still feel obliged to provide the information to the IRS?
The answer is unless the regulation is deferred. And by the way, when the RFA says deferral is a possible remedy, it is immediately followed by a clause that says, unless the court determines that it's in the public interest, it should not defer the regulation.
My question to you, though. I'm asking if you get the relief you want, and I'm talking about in particular the form in your brief here that is no injunction, but is simply a remand to comply with the Regulatory Flexibility Act, then will your client, in the meantime, until they do that, will it use these regulations to whoever the client is here, to figure out what tax is owed?
If the regulations remain in effect as they would under your hypothetical, the answer is yes, of course.
And if your other option is actually to enjoin these regulations, like the same thing happens, the legal obligation to pay the tax remains. So if these are then enjoined, how does your client figure out how to pay the tax?
Your Honor keeps focusing on the tax liability.
Look, all we know is you said one time your client wasn't subject to the tax, but your client apparently is in a position where on a recurring annual basis, he has to figure out if he owes anything under the
Correct.
tax. And that obligation will remain.
Correct.
And if he guesses wrong, he's going to be subject not just to the tax, but to interest and penalty. So I'm assuming your client will go ahead and figure out if he owes the tax, even if these regulations are deferred. Is
He
that
will,
correct?
but that's not what
How
we're,
is he going to do that? Regulations, that's my question to you. Is there a way to do it without these regulations in place?
or defers the regulations. Going to be very difficult, okay, for him to do that. But they've already published the regulations. It's possible for him to take the deferred regulations and use them and the Form 8992 and to figure out these payments and make his elections and pay whatever or not pay whatever he has to pay. Absolutely correct.
Will they still be able to meet their legal obligation to pay the tax if we give you that relief?
I believe they can, and it will just cost them a whole lot more to comply with it than we're even claiming in this case. But I think your hypothetical presumes something that is not essential to our case. We simply, in our complaint, listed the remedial options that are set forth in the RFA. One is remand. It's a separate section, 6111A4 under A. And the second paragraph, separate section, is deferral. Deferral subject to the public interest language that I mentioned earlier.
But they
No.
go together. There are two requests for relief, 1 and 2.
Well,
You ask for a remand and then for full compliance with with these provisions, and then defer enforcement until there's compliance with those provisions.
we did.
It seems that your request for relief is remand, and while we're remanding, defer enforcement. Otherwise, what are we deferring for?
Well, our position, Your Honor, has been to say that the remedy for an RFA, remember, all we're trying to do in this case is get a court to ascertain whether the IRS complied and had substantial evidence to support its claim that there was that it could certify non-compliance.
I understand that. It just seems to me that if we think that this regulation is an assessment of tax, and it does say that it provides rules to determine a United States shareholder's income inclusion under Section 951A. So if we think this regulation is an assessment of tax, and you're saying we need to defer while we remand, why doesn't that violate the Injunction Act? You're restraining the assessment of the tax.
What I'm saying to you today, Your Honor, is
I don't care about what you're arguing today. I care about what's in your complaint. And your complaint says defer enforcement during this remand, and that deferral of enforcement. Please don't interrupt, counsel.
Sorry, just
It seems to restrain the assessment of a tax. That violates the anti-injunction.
Sir, our position is that irrespective of whether the regulations are considered to be a tax regulation, let's assume for the sake of argument that they are. Okay, what we're saying is, and consistent with the Supreme Court's approach in CIC and in the earlier direct marketing case, that what all we're doing under the RFA is asking for relief from the increased compliance costs, okay?
Yeah.
And that we are not asking.
Deferral of enforcement.
No, we don't need to do that. We listed the remedial provisions in the complaint, and the court, it's up to the court to decide what remedy it should apply. When the same issue came up in Silver One before Judge Mehta on motion to dismiss, and remember, we are on motion to dismiss. We're not on summary judgment stage. On motion to dismiss, Judge Mehta clearly said, listen, this is premature. The Anti-Injunction Act doesn't work like some of the jurisdictional statutes that we're familiar with involving immunity or federal question jurisdiction. It's the jurisdiction stripping statute, at least as this court has interpreted it. And what the Judge Mehta said, and which we agree with, is the proper analysis, is that until you get, the court finds that there has been a violation of the RFA, then the whole question of Anti-Injunction Act defense and is premature. It just doesn't come up. In fact, if the court decides that there is no RFA violation, that stops the question there.
So if we read your complaint to be asking us to defer enforcement of the final rule, and we read the final rule to be an assessment of taxes, then this would violate the Anti-Injunction Act, correct?
No.
Why not?
Because what this case is about, what the complaint is about is,
But that's not my question. My question is, if we read this complaint
I'm
to
accepting.
request defer
Mhm.
enforcement of the final rule, and we read the final rule to be an assessment of taxes, would that violate the Anti-Injunction Act?
Okay,
It's a yes or no question.
answer is no. And the reason is no, is because this lawsuit, the lawsuit that's set forth in the complaint at the motion to dismiss stage, is about the RFA, and the Congress. This is probably the only statute that I'm aware of where the Congress, when it passed the RFA in 1980, again in 1996 is the relevant time frame, actually took into account this question that your honor is asking. How do you accommodate the Anti-Injunction Act with the RFA requirements, which are by definition always going to be pre-enforcement challenges to the our IRS rulemaking? Okay,
But you said defer enforcement of the final rule. The final rule, there's more to it than the RFA aspect of it.
no, but
And if we think the final rule is an assessment of taxes, this would violate the injunction.
if you look, your honor, at section 605 of the RFA, this subsection C. It says, in order to avoid duplicative action, an agency may consider a series of closely related rules as one rule for the purposes of section 602, 603, and 604. What they did in this case is they incorporated in the GILTI regulation not only all of the panoply of definitions and formulas and examples that you read in the first 338 pages of the rule, but also these two rules that create for the first time this record-keeping, information-gathering obligation upon the businesses. That's exactly why the RFA was passed.
I think I understand your question.
Okay.
We will give you a full minutes of speaking.
Thank you, Your Honor.
Good morning, Your Honors. Douglas Rennie for the defendants. Your Honors, there are two issues in this case. The first is whether the plaintiff's suit to defer the enforcement of the Treasury regulations against themselves and other small businesses is barred by the Anti-Injunction Act's prohibition on suits to restrain assessment or collection of federal taxes. The second is whether the plaintiffs lack Article 3 standing because they cannot show that Treasury's failure to conduct a full Regulatory Flexibility Act analysis affected the content of those regulations, or that any change to the regulations from such an analysis would affect their future compliance costs.
Well, first question, how is this case not controlled by Supreme Court decision in CIC? This is an information gathering provision that allows an assessment to be made. It's a pre-assessment information gathering provision, just like in CIC. And the Supreme Court said, pre-assessment information gathering, challenges to that type of informational requirement from the IRS is not barred by the Anti-Injunction Act. That's this case. It's on all fours with CIC.
We would submit that that's not the case here. It is not just an information gathering requirement, because it also, in addition to the specific regulation that Mr. Zell's referring to, there are numerous other regulations that discuss the calculation of GILTI and several anti-abuse regulations, which indicate certain situations, address certain situations where the tax might be
Anti-abuse
calculated
situations is what CIC was all about. We need to get information from you to see if there was there were problems going on with particular types of tax transactions there. That's what CIC was all about.
Right.
The fact that you gather information and then use that information to compute your taxes, if any, does not change the fact that this is pre-assessment information gathering. We all engage once a year in pre-assessment information gathering, and some of us have to provide that information to the IRS, but that is separate from the assessment. You're asking them to give information. How is them providing information the IRS's assessment of a tax?
That information is reported ultimately on Form 1040 in terms of this is their income, this is their taxable income, and the tax due.
Sure.
It is a form of self-assessment.
I have to gather what this year before I can fill out my taxes. I got to figure out what my gross income was. That process of getting papers together is called information gathering, not the assessment. Someone then takes that information, either the taxpayer or they provide it to you all and you all do the computations. But you use the fact that you use the information to figure out what, if any, taxes due is no different from CIC. That was the whole point of the information gathering process in that case, was to provide information, and same for the digital services case, to provide information to figure out if a tax is due or not. But the regulations about information gathering, the Supreme Court could not have been clearer, are pre-assessment, and so are not covered by the Anti-Injunction Act. I'm gonna get overruled if we rule for you. I don't understand how the CIC doesn't control this case.
We don't think that's the case, Your Honor. There are several important differences here. This is reporting it on, ultimately on Form 1040, the tax owed is a form of self-assessment.
Ultimately, after they get the information, they use that information to figure out what numbers to plug into their form. Is that your point?
Yes, that is a
In
self-assessment.
CIC, they had to go through all this information, figure out if something wrong was going on, or something wrong was going on. They needed to report that to the IRS and pay tax on it. That's the exact same thing. That's no difference at all.
It's different because there was another difference in addition to the fact that it's a form of self-assessment, and as Judge Kavanaugh said in the Seven Sky case, before in this court, in his dissent, is that the CIC, it was not a regulation. It was a notice issued concerning micro-captive transactions. Micro-captive transactions were not taxable under the notice.
Why does it matter whether it's a regulation or a notice?
Because the notice was backed up by a statutory penalty that the IRS could apply in its discretion.
You've got statutory penalty. Look, there's no question that the obligation to pay the tax, if anything is owed, exists. It exists independent of your regulations. Congress did not make the applicability of this tax contingent on your regulations. And in fact, as best I can tell, there was an entire tax year when this tax had to be computed and determined to be owed or not, and if owed, paid, before there were any IRS regulations. So it's pretty clear these regulations are not a necessary predicate to payment of the legally required tax. They instead are a way that the IRS wants to get information that it can use to make an assessment. But the information is not the tax, correct?
That's correct, but the process of reporting that information is reporting the tax due is self-assessment. We would submit that's material different.
They have to report whatever information is needed to calculate their tax with or without your regulations.
Yes.
They had to do that in for the 2018 tax year, correct?
Yes.
So
and
these regulations are distinct from that. The fact that you ultimately take that, their problem is with the information gathering and all the paperwork, not with the 1044, right? It is with all that process. That's what they say you guys did right or wrong. I'm not mentioning the merits here of the Regulatory Flexibility Act claim. We're at a jurisdictional stage, but assuming they're right, which we do at this stage, assuming the government didn't comply with the Regulatory Flexibility Act, it's made procedures, which they say made it harder, not easier, to comply with this tax. And those procedures, which are all about information gathering, are exactly the type of thing that we've been told twice by the Supreme Court is not covered by the Anti-Injunction Act.
So I'm sorry, my understanding of the reporting requirements in CIC were that they were reporting requirements that didn't actually impact the tax liabilities. They were separate reporting requirements. Whereas in this case,
That's correct.
there are reporting requirements, but there are also rules to determine a United States shareholder's income inclusion, which affects your self-assessment.
That's correct.
So in that respect, if it's a self-assessment, then it is subject to potentially the Anti-Injunction Act. Like
That's our position.
all taxpayers initially do a self-assessment. And I think there's a case HIB that says that that's part of the assessment process. And it seems that these regulations might be distinguishable from those in CIC because there are some reporting aspects of this, but the reporting aspect in CIC was not one that impacted the tax liability, the assessment. Whereas these regulations, part of it's reporting, part of it does affect your assessment because it tells you what's included in your income.
That's correct, Your Honor.
No.
Renee, can I ask you, I'm going to go back to the statute, the Anti-Injunction Act, and see if I understand your position on behalf of the Internal Revenue Service. The statute doesn't focus on the court's action. It doesn't focus on what the court would agree to in terms of a remedy or any of that, because it talks about, this is a question. Is it your point that when the statute says no suit for the purpose of restraining an assessment or collection is allowed? It's the suit that's not allowed and the purpose of the suit. Is that your position?
That's correct, Your Honor.
Right. So so in other words, you couldn't escape the Anti-Injunction Act on the basis, for example, of saying, well, the plaintiffs here sought an injunction, a set aside of the regulation, which would have interfered with the collection of taxes. But the court doesn't have to grant that, so therefore will allow the suit to go forward, even though they were maintaining the suit for the purpose of doing something the Injunction Act prevented. That's a long question, but I think you get it.
Yes.
Is that the gist of what we're talking about here?
That is our position, Your Honor. We think it's a jurisdictional issue that is properly presented on a 12-1
And the focus
motion.
is on what the suit, the purpose of the suit. And the only way you can find that out is to take a look at what the allegations are.
Exactly, Your Honor. And that's what the Supreme Court said in CIC services.
I think it said, look at the prayer for relief. And so if one option is not barred by the the Anti-Injunction Act, and another form is, what happens?
Well, they've asserted them both. They've
No,
not.
I'm just asking a hypothetical. If someone said here, just remand, don't defer the regulations. So if the complaint said remand or defer.
It goes back to what the purpose of the suit is.
So
And
here's what is the answer to that question?
I don't know if I can answer that in
Well, that's an
isolation.
answer that our court gave a long time ago. In a case called Sanchez versus Espinoza, an opinion by Justice Scalia. If there's a suit and one count says we want an injunction and the other says a declaratory judgment, which I take it is the question. The Sanchez opinion by Justice Scalia says when it's against the government officer, that amounts to the same thing. Because we assume the government officers are going to comply with the law. So if you just give a declaratory judgment, it's the equivalent of an injunction.
We would agree with that, Your Honor.
Yes, but if you simply ask for remand for compliance with the Regulatory Flexibility Act.
Yeah.
And so that does not affect the collection process, doesn't affect this regulation, has no effect on the regulation, has no effect on the collection of information, has no effect on the obligation to file the tax or the tax that is due. I mean, the Declaratory Judgment Act itself has an anti-tax provision, so that's different. But if all they ask for, imagine there's a complaint with a single request. The only request is please remand for compliance with Regulatory Flexibility Act. Do not defer the regulations. What happens then?
I think they'd have a much stronger argument.
Would
here,
that, in the government's view, be barred by the Anti-Injunction Act?
It's difficult to say because the statutory remedy also says that
There'd be
the
no
court,
injunction affecting the assessment or collection of taxes.
the statutory remedy says that the court shall order deferring the enforcement of the rule in this case, in addition to remanding the rule to the agency. And this court's case law tells us
You
to
read the
look.
Regulatory Flexibility Act is, it's forbidding a remand without injunction.
It doesn't. It allows it if it's in the public interest to have continued enforcement.
Public interest would certainly be informed by the public interest in revenue collection.
Yes.
So if you have a single count for relief, and that's what the Supreme Court has said to focus on in these Anti-Injunction Act cases, let's look at the claim for relief. If you had a single count claim for relief that said just remand, not barred by the Anti-Injunction Act.
I think if you were specifically pled that continued enforcement of the rule is in the public interest and disclaimed any.
Why do they have to plead that?
Because,
I'm telling you, look at the request for relief.
because the statute provides that that is the relief, is the presumption is deferring the enforcement of the rule or regulation.
But
But
someone pleads, just remand this. I just want compliance with Regulatory Flexibility Act. I don't want to mess anything up.
right, but I think they would still have to plead facts establishing that it's in the public
Assuming they-
interest.
Then what?
Then I think that that would probably be a way to get around the Anti-Injunction Act.
CIC, people were subject to penalties, right?
The material advisor, the petitioner there was potentially,
Penalties are taxes in that case, correct?
right, but they
So
were
the
discretionary.
information, effective ability of the IRS to figure out whether those taxes were due, correct?
Not necessarily. The information would allow them to assess whether the transactions were abusive because microcap.
Right, the reason you wanted the information was to figure out, I mean, anytime you figure out whether the tax was owed or not. You do that all the time, right?
Yes,
So the point of the information in that case was to provide information to the IRS so that it could figure out whether a tax was owed or not, correct?
at some point, yes,
At
but
some point, that's what it was all about. They were trying to figure out that there were these sham transactions. They needed information. They said, provide this information. And we will use this information then to determine if a tax is owed or not.
ultimately, yes.
Okay. That's the court said the Anti-Injunction Act didn't apply.
Excuse me, Your Honor.
Supreme Court said no Anti-Injunction Act problem there. Correct?
It's several steps away, Your Honor,
Correct. Supreme Court said no Anti-Injunction Act there.
in that case, but we think there are several distinctive facts about that. And what we have here is reporting for self-assessment. There you had an upstream penalty that would only apply in a discretionary situation.
Is the reporting only for self-assessment or does the information get turned in as part of their forms, the IRS?
In this case or in that case?
Sorry, in the,
Is it used only for self-assessment or is it turned in?
I mean, it's reflected in the forms that are filed with the IRS, correct?
Yes,
Okay. Not just self, this is information provided to the IRS, so the IRS can do what with that information?
it's to determine the proper tax
Determine
liability.
determine tax liability, which is called an assessment, correct?
There's
correct.
a self-assessment and then the IRS can audit that through a process of
To
double checking.
determine The IRS provides information. Check.
Eventually, yes. I see I'm over time, Your Honors. Does the court have any further questions?
Thank you very much.
Thank you.
Mr. Zell will give you 2 minutes.
2 minutes, thank you. Your Honor, the government counsel made an extraordinary statement here in response to Judge Pan's question. He said self-assessment is equivalent to assessment for purposes of the Anti-Injunction Act. That is not what the Anti-Injunction Act is about. And the court said, as the court said in direct marketing, which is under the TIA, the two statutes are interpreted together. Those terms, restrain, and these terms assessment and collection, have very narrow meanings for purposes of the Anti-Injunction Act. Just think what the government has told you here. They said that anytime that you submit a tax return in which you're self-assessing your tax liability, the Anti-Injunction Act will apply across the board.
Well, if there's a regulation that determines what my self-assessment is, for example, say the IRS said I can't deduct my mortgage anymore, and I wanted to challenge that. That would affect my self-assessment because I first have to put that in my taxes to calculate what I owe. But what I have to do is pay the taxes and then challenge.
That's what the Anti-Injunction Act would say in
Exactly,
that
but I'm
case.
just saying your self-assessment is the assessment of the taxes.
Yeah, we're saying that's right. Every case, well, Your Honor is correct. In every case where you're self-assessing your tax liability, the Anti-Injunction Act would apply.
Well, if I want to challenge a regulation, I would have to follow the Anti-Injunction Act, pay the taxes, and then challenge. That's how it would apply in every case.
That's how it works. That's what the Anti-Injunction Act works. That's not what the RFA is supposed to work. The RFA, I urge Your Honors, I have 12 seconds. I urge Your Honors to read the legislative history at 142 Congressional Record. Yeah, sure.
5 years have elapsed. This tax has been, in fact, all we're told is that he didn't owe any tax for 2018. Has Mr. Silver owed this tax in any of the subsequent years?
I don't know the answer to that.
Well, if he did, he sure would have a way to challenge this, wouldn't he?
Well,
You've argued the South Carolina
under what the
exception.
interpretation I've just heard here, he would not. He would have to pay the tax. You have to go pay.
Challenge.
Yeah, but not just pay the tax. Yes, we have.
But if you can't tell me that he hasn't paid this tax in subsequent years, then how are you eligible for that exception?
Well, all I have to do is cite the government's brief on this one. They tell you exactly how we have to go about answering Judge Pan's question about how we would comply with the Anti-Injunction Act to raise this question under the RFA. We'd have to go not make a 962 election.
No, that's what happened in that year. You can't tell me. It sounds like you can't tell me that in subsequent years, he just didn't owe this tax. If he did owe it in a subsequent year, he could have raised his challenge then. And you can't tell me that it was anything about, if he did owe it, then you had a perfect vehicle right there for challenging this.
I'd have, if he owed the tax, I would have to then.
He owed it in 2020.
Okay, in a situation like.
Pay the tax, then he can
Well,
Yes?
assuming the Anti-Injunction Act applied in that instance, okay, we would say it does
If
not.
he's paid the tax.
Hmm?
If he's paid the tax, why doesn't it apply?
Well, that's a question where the South Carolina, and in a situation like that, the South Carolina versus Reagan exception to the Anti-Injunction Act would be problematic. Okay, but it's this argument that the self-assessment is assessment within the meaning of the Anti-Injunction Act is completely off the mark. Okay, and would allow.
I think we heard your argument on that point.
All right, with that,
Any question?
I'd ask the court to reverse the district court on the issue of AIA and affirm on standing. Thank you.
Okay, just a minute.
Case number 23-1030, et al. Hig Vision USA, Inc. petitioner versus Federal Communications Commission and United States of America. Mr. Wright for the petitioner, Hig Vision USA, Inc. Mr. Blau for the petitioner, Dahua Technology USA, Inc. Mr. Dunn for the respondent, Mr. Johnson for the intervener.
Morning.
Yeah, please, the court. Christopher Wright representing petitioners which manufacture video surveillance equipment. As I will explain, Congress carefully limited the covered list to equipment that is both essential to the provision of broadband service and has certain dangerous capabilities, and video surveillance equipment does not belong on the list. Mr.
Counsel,
Blau
let
will
me
address
ask
the
you,
critical infrastructure.
If I can ask you about this. According to Congress, video surveillance equipment manufactured by Hikvision and Dahua is covered equipment that's a potential threat to national security. That's what Congress said. And then the FCC placed that equipment on the covered list because it's a potential threat to national security and subjected it to certain restrictions. Federal subsidies can't be used to purchase it. The FCC then decided to expand the restrictions on the covered equipment that is a potential threat to national security. And the commission said that it would not provide authorizations for that equipment. Congress then weighed in and said the FCC may not allow equipment authorizations for equipment that, again, is a threat to national security, that is, quote, on the list of covered communications or services published by the commission, unquote. You want us to interpret all of that to mean that Congress intended to ban equipment authorizations for only a sliver of the equipment that Congress thinks is a potential threat to national security, only the sliver that's essential to broadband capability. And though Congress said that the equipment ban should apply to equipment, quote, on the list published by the commission, unquote, you want us to hold the opposite, that it actually meant to allow equipment authorizations for most of the equipment that is on the list published by the commission.
So if I may, let me note that it's far more than a sliver that would be covered under our view. But let's look at the statute. So I'm looking at the statutory addendum that petitioners filed. I'm looking at page 55 of that statutory addendum.
It might be, because some of us have our own versions of the statute. You just tell us which statute.
So I'm looking at section 2C, which contains, pardon?
Which statute? The SEA? Which statute are you looking at?
The Secure and Trusted Communications Network. Yeah, I'm sorry, there's so many statutes involved in this.
Yeah, no, that's why I wasn't sure. The secure.
What page of the addendum is that on?
55, and it's subsection C, which contains the cross-reference that Judge Pan was talking about. And this makes clear that there's very limited purpose for this cross-reference. First,
You're going to have to back up again. Are you talking about the Secure Equipment Act 2021?
no, I'm so the Secure Networks.
You're talking about 1601 subsection C, reliance on certain determinations.
That's right, Your Honor. So the parties have largely referred to it as 1601 as section 2, and that's how it's listed in the statutory addendum. So, but in any event, it says in taking action under subsection B1, the commission shall place on the list 4 different things. And the third one is the cross-reference to 889F3 that I believe does not have the consequences you're suggesting. But so it's the first line again is in taking action under subsection B1. If on the prior page, section B1 is listed, and it follows the threshold requirement that only covered communications, which is defined.
I understand that you're drawing a distinction between communications and telecommunications equipment, but since you're talking about subsection C has 4 different purposes or means by which we can make a determination. And it seems that it's referencing Federal Acquisition Security Council findings, as well as Department of Commerce findings pursuant to the an executive order. And those provisions talk in very broad terms about the types of issues they're addressing. For the Department of Commerce executive order number 13873, it talks about vulnerabilities in information and communications technology and services, malicious cyber-enabled actions, and economic and industrial espionage against the United States and its people. And it encompasses any hardware, software, or other product or service primarily intended to fulfill or enable the function or information of data processing, storage, retrieval, or communication by electronic means. The Federal Acquisition Security Council targets security threats to covered articles in the supply chain, and its mandate includes information technology, including cloud computing, services of all types, telecommunications equipment and services, related hardware, software, systems, and devices. And Congress cross-referenced these security threats and instructed the FCC to place these entities on the list based solely on these determinations. These determinations are broad, but you're saying that Congress intended only to address the sliver that deals with broadband.
Yes, Your Honor. So let's go back to the statute. Again,
I just
there
quoted
are-
to you from
yeah.
the statute and the references it's cross-referencing. How do you explain
So I'm sorry.
references to the federal acquisition? If I may ask the question, how do you explain the cross-references to the Federal Acquisition Security Council and the Department of Commerce? And how is that consistent with your definition that communications equipment can only relate to broadband services?
Because that's what the secure network does. And it has three requirements. And the first is the threshold requirement of communications equipment. The second is the B1 determination by one of those four entities listed in subsection C. And a third requirement, it has to be, the equipment has to be capable of certain dangerous capabilities that the FCC.
But doesn't that list seem
supposed
to
to design.
contradict your view of what communications equipment is?
So
You're interpreting it as a very narrow thing, and what they're cross-referencing are very broad things.
So let's remember that what Congress was doing when it adopted the Secure Network Act was deciding what it would pay for under the RIP and Replace program. That's the bulk of that act, Section 4. And Congress wasn't saying that it was paying to rip and replace everything. Certainly wasn't saying that it was going to pay for ripping and replacing all the things that are in C, because it has two separate requirements.
But the reason these entities were subject to the rip and replace requirement is because there was a finding by Congress that they're a threat to national security. Correct?
That satisfies B1. The entity, the focus on B1 is on the entities providing the service or the equipment. The focus in B2 is the capabilities of the equipment. And of course,
do you dispute that Congress has made findings that this equipment is a threat to national security or potentially so? What about the 2019 NDAA, Section 89F3?
So Congress decided in the NDAA that it wouldn't allow federal agencies to buy equipment.
I understand all that. I'm just saying the reason these companies were subject to it was because there was a finding that they're a threat to national security, correct?
A threat. Let me say
correct.
that even in the NDAA, Congress did not prohibit federal agencies from buying.
I understand the effects of it. I'm just dealing with the categorization of a threat to national security. And I guess my question is, why do you read the SEA, the most recent act, to only address a sliver of what they think is a threat to national security?
Because in the Secure Networks Act, Congress said it was only covering equipment that was essential to the provision of broadband and had the dangerous capabilities listed in Section 2B, as well as meeting the requirement of 2B1.
There's also a definition in Section 16085. This is 47 USC Section 16085. That covered communications equipment or service means any communications equipment or service that's on the list published by the Commission. Your client's equipment is on the list.
It shouldn't be on.
That's a different question. It is on the list. And 16085 says if it's on the list, it's covered equipment
Well,
service.
Your Honor, but that follows 4, which says that it has to be equipment essential to the provision of broadband service.
There are a lot of different definitions here, but it just seems to me, if we take a step back and see what Congress was trying to say, is that they were saying, as clearly as Congress ever does, that they think
Your Honor,
that your clients should not get
I think-
equipment authorizations.
I think Congress said as clearly as, remember, this is a statute that doesn't have to do with equipment authorization. I think that it's very.
No, I'm talking about the Secured Equipment Act, which does deal with equipment
So,
authorizations.
well, we were looking at 9.5, but in any event, I think Congress.
If we can just look at the Secured Equipment Act together just for a moment. It says there will be rules subject to a specific notice of proposed rulemaking, which involved expanding the consequences for being on the covered list. And it says in the rules that will be adopted, the commission shall clarify that the commission will no longer review or approve any application for equipment authorization or equipment. So we'll have no equipment authorization. For equipment, quote, that is on the list of covered communications equipment or services published by the commission.
So,
Your client's equipment is on the list.
so Your Honor, that's the ratification argument. If I could make one more
It doesn't
comment.
say properly on the list. It says anything on the list.
Well, Your Honor, the Secure Equipment Act, it changed the consequences of being on the act and did so rather dramatically. But Congress didn't say anything that's on the act improperly should. And Congress also in the Secure Network Act said that, things will come on and off the list. That's
Things can come on and
section
off the list,
So-
but it's saying at the time that they enacted this rule, the equipment that is on the list published by the commission, there will be no equipment authorization for that equipment. That's what this says.
Well, Your Honor, our position is that if this court decides that the equipment at issue is improperly on the list,
But how
the
does,
CC should
if
take
you
it
can
off.
just tell me textually what allows us to look behind what's on the list? It says just on the list published by the commission. It doesn't say properly on the list. It doesn't say correctly put on the list. How are we allowed to do that based on the statutory language?
I think this court has the authority to review what the FCC order at issue. And the FCC order at issue decided that.
But the FCC order has to comply with the statute.
And the statute says that the commission has to decide 3 things. And I think this is a statute
I'm
that's
looking at the
very clear.
FDA, the Secured Equipment Act.
Um,
The regulation that you're challenging was issued to implement the Security Equipment Act. The Security Equipment Act says if it's on the list, no equipment authorization.
Well, Your Honor, that would also then mean that Congress is willing to pay to rip and replace this equipment because it's the same list.
Okay, that's a consequence of it, but the words of the statute are the words of the statute.
Well, the words of the SNA make very clear that
And the
there
SCA
was-
says published by the commission under the Secure Networks Act. Doesn't just say published on the list. So I take it your argument is it has to be published under Section 2A of the Secure Networks Act. And I assume your argument is that brings in the obligation that the list be in compliance with the Secure Networks Act. Is that right? It's the list that is compliant with the Secure Networks Act. That's your reading. And your reading is that your placement on the list is not.
and again, the commission has the duty to review and revise that list, add to it and subtract from it. And if this court says that video surveillance equipment didn't belong on the list, then it should take it off.
Well, I'm making a narrower point is that the Secure Equipment Act didn't just say equipment that's on the list. It says equipment that is on the list of covered communications equipment under the network, what I call the Secure Network Act. And your argument is that's fine, but we're not on a list of covered communications equipment under the SNA as a matter of law. We're not there lawfully on that list. I take it that's your argument, because we are not in fact, I mean, to be covered communications equipment, you first got to be communications equipment.
So if this court holds that video surveillance equipment should not have been on the list, the commission will take it off, and then video surveillance equipment can obtain certification until and unless Congress rules differently.
Because there is the express reference to section 889F3 of the NDA, 2019 NDAA. What in 889F3 would qualify under your view as communications equipment? You would say nothing in subsection B.
So telecommunications equipment produced by Huawei and ZTE and services provided by those companies.
I just want to talk about equipment, not the services language. So just focus on equipment, not the services language. So what equipment in 889F3 would?
So equipment that's essential to the provision of broadband.
What in 889F3 can you tell me? Are you saying that Huawei's telecommunications equipment would does qualify as covered equipment?
And just to get a little more granular, might be useful. I mean, so this equipment is the equipment that internet service providers need to use to provide broadband service, the transmission service. And that's what Huawei and ZTE mostly provide: the routers, the gateways, fiber, all of the stuff in the network is
Essential broadband.
if they're in the network, there's a line between what internet server providers do, which is essential to the provision of broadband. And then there's what end users attach to the network. And that's not essential to the provision of broadband. You can provide broadband service without video surveillance equipment. No one disputes that. So it's not essential to the provision of broadband service, doesn't make it through the threshold. But Huawei and ZTE equipment would. And excuse me?
All of it, all of the telecommunications equipment by Huawei and ZTE?
I don't know that it's, I don't know if they sell things other than routers and gateways and all of this stuff that makes the network, but they're major providers of that.
Is there anything Huawei creates or produces and sells that would qualified as communication equipment?
No, they're video surveillance equipment providers now. I would note that.
I'm sorry, they only do video surveillance equipment.
And
do they do any switches or routers or wireless bridges, or would those not count?
Well, they don't right now, but of course they could.
Have in the past?
Except if they did, no. But if they did, they wouldn't be able to, it would be covered, it would be on the covered list, and they wouldn't be able to get it authorized. So it would have an effect if they sold that kind of equipment.
It's like a supplemental router. A security system that has a supplemental router needs to buttress the router service provider.
As a class, they wouldn't be able to sell that. Anything that's used, of course.
Would that count as essential to broadband services?
Yes. An internet service provider is going to have lots and lots of routers and gateways and all sorts of fiber and things. And you know, yeah, it's designed so that if one of them fails, probably something else will step in. But we agree that what internet service providers buy from companies like Huawei and ZTE and the service they provide, that's what's covered. And that's what the findings of
What if your clients is installing their video surveillance security system, installed sort of supplemental routers to strengthen whatever the signal is so that it can now support all the needs and demands of the surveillance system?
So, well, with respect to sort of the boundary issue, we did put in the record some of our comments that are designed to show the difference between where the boundary of the network and customer premises equipment lies. And remember, that's the traditional distinction. The FCC has since 1934 regulated networks, telecommunications networks, but not CPE, not customer premises equipment, unless there's some specific reference. So this is a natural line to draw. And again, Congress was interested in protecting networks and communications while they're on the network. And it wasn't interested in paying to rip and replace all of the equipment that customers and users attach to the network. This was a carefully limited statute with 3 requirements, and 2 of them aren't met, and all 3 requirements have to be met.
How do we know, relevant to Pan's question, I think the difficult question in this case is what the Secure Equipment Act of 2021 was doing. It was certainly saying this will be the consequence for being on the list, right? Barring authorizations. But how do we know that it wasn't also when it says, barring authorization for equipment that, quote, is on the list, in the list, the only equipment on the list are the things listed in 889 F3. That's the only stuff that's on the list at the time. This isn't like, it's not like it's a 40-page list that Congress wouldn't have been aware of. It was for equipment. It was the 889 F3 equipment. And so it seems, I get your textual argument. It's just, I'm struggling also with,
So
how do we assume Congress didn't know what the composition of the list
Congress also knew what it said in 889 F3, although the FCC didn't, in terms of relation to 889 A2. That's the provision that says nothing in this section covers equipment that cannot route or redirect user data traffic or permit visibility into any user data or packets. That's very parallel to the requirement in 2B2 of the Secure Networks Act. But what it means is that Congress wasn't even prohibiting federal agencies from buying video surveillance equipment. And that's clear if you look at the addendum to our reply brief.
Wait, so are you saying this, when Congress says in 889 F3, that video surveillance and telecommunications equipment produced by your clients and other companies, count as covered telecommunications equipment. In fact, they don't, because they don't satisfy 889 A2B?
Yes, Your Honor, and 2 points on that. First, that's made very clear by the addendum in our reply brief, which is GSA's interpretation of 889. And the commission just missed, or if it saw it, it failed to note that the A2 provision. But GSA makes quite clear in what gets called the decision tree that you first look to see if you're a federal agency and you want to buy video, some sort of equipment. Is it mentioned in F3? If it is, you then look at the A2, which I just read. And if the answer is no, it can't do these dangerous things, you can buy the equipment. And again, it was critical to the FCC's misunderstanding that it thought that Congress in the NDAA had said that anything that's unlisted in F3, federal agencies can't buy it.
But
that's just wrong.
Secure Networks Act only references 889 F3 equipment and does not reference 889A.
So it says that equipment shall be on the list only if it meets the threshold. And then if and only if it satisfies the requirements in B1 and B2, 2B1 and 2B2. And 2B1 has cross-reference, but 2B2 is very parallel to 889 2B because, if we turn back to the Secure Networks Act and look at Section 2B2, which is on 54 of the statutory addendum, you see that it first has to be communications equipment. And then it's on the list if and only if it meets B1 and meets B2. And B2 has this list of dangerous capabilities that, as I just said, are very parallel to those in 889. I think the text answers the question, but the court might also note that, again, Congress in adopting the NDAA was very focused on Huawei and ZTE, made detailed findings. And that's what this, it was an amendment. It was an amendment that added F3. And as we discussed in a footnote, the amendment wasn't the result of any careful study. It was.
You can't write opinions saying that we think Congress was just kidding.
Well, especially
when it passes a later statute that references it.
So
your network that explicitly references it.
So it references it, but Congress, it still doesn't pass the A2. So I'm just saying it's not surprising that there might be something on that list that federal agencies could buy. And perhaps that's how, I don't know that I'd write that in the opinion, but you're kind of, the consequence of the cross-reference still has meaning. Anything that's in F3, as the decision tree shows, before an agency buys it, it has to consider whether it has these dangerous capabilities.
So for agencies,
yes. And
have they been
I don't know the answer to that question. The record doesn't say.
Agency government behavior reflects what you're saying. They read the statute. The rest of the government reads the statute the same as you. I would think this would put them off.
Yeah, I mean, I will note that the military's response was, these cameras don't present any national security threat. We don't even have them attached to the internet, which again, I mean, not only is this equipment not essential to the provision of broadband, you can use it without even attaching it to the internet.
Give you some time on rebuttal. Thank you. Are companies planning to do about it or just one?
May it please the court. The FCC adopted an unreasonable interpretation of the term critical infrastructure as used on the covered list designation of Dahua and Hikvision equipment. This interpretation flies in the face of the consistent use of this term by Congress in previous statutes and by other agencies throughout the government. It's so overbroad that it creates effectively a presumption that everything in the entire economy is critical, and it's implausible on its face.
If they had just adopted the definition of the Patriot Act without the additional connected to language, would you have any challenge?
We would not be here arguing this point today if that were the case. The FCC didn't stop there, though. As you know, it went on and cited the 16 sectors, one of which is commercial facilities, which of course encompasses a huge portion of the economy, and 55 functions, and said that anything connected to one of these sectors or functions could reasonably be considered critical infrastructure. That's unreasonably broad. Critical means indispensable, vital. And the Patriot Act definition incorporates that concept. And the Patriot Act definition has also been used in several other statutes, including another section of the 2019 NDAA, which is where Section 889 was adopted. The FCC got these 16 sectors from a presidential policy directive. But while the presidential policy directive defines the sectors, it never says that anything connected to one of these sectors is necessarily or even presumptively critical infrastructure. It designates a specific federal agency to oversee each sector and strengthen the security of critical infrastructure within that sector, something the FCC probably knows because they're one of the agencies that's designated in that directive. The FCC says that our examples of laundromats and used car lots are far-fetched, but they don't say why. They certainly don't dispute that those are commercial facilities and therefore connected to one of the sectors designated in the policy directive. But they say that it couldn't reasonably be considered critical infrastructure. If they can't articulate why that is, then how is any party supposed to determine what critical infrastructure is or is not? The FCC and the interveners suggest, well, you can always go back and ask for clarification. Clarification will be provided by the FCC staff, who of course are bound to apply the order that the commission has adopted. So I don't think that I think that's an illusory remedy. If the court has no other questions, I'll reserve the rest of my time. Thank you.
Thank you. Government now.
Good morning, Your Honors. I'm Matthew Dunn for the FCC in the United States. I would say this APA challenge is a little unusual because the agency is doing so specifically what Congress told it to do. Here we had an NPRM in which the agency proposed a course of action. As you know, that's refusing to further authorize equipment on its covered list. And then Congress passed a statute saying, yes, referencing this NPRM by the docket number and saying, yes, you should do exactly what you proposed to do.
So you read the statute as not only prescribing consequences for being on the list, but as also ratifying the content of the list?
We do read it that way. I think the first prong is sort of unassailable, but also I think there's strong evidence for the second, yes.
What's your best evidence that that's the reasoning? Because it does say the list published under Section 2A of the Secure Networks Act, which has lots of requirements, that they say we're not satisfied in this case.
It does. I think so textually, you can read it as well as I can, but I think that the context speaks volumes here. So there's a kind of iterative back and forth between Congress and the FCC. Congress was the one that first named these companies in the 2019 NDAA. And
It's
then
telecommunications equipment, but then it's the same Congress that chose for the Secure Networks Act to use a different phrase, specifically defined to require that you be essential to, for shorthand purposes, broadband services. So Congress chose a very narrow definition there, which did not map onto the 2019 NDAA language. And so I'm trying to figure out what the iterative process is here.
I would like to get to that, but just to finish answering your question about the meaning of the Secure Equipment Act, I think it would be a strange course of action for Congress to think that the FCC had gotten it wrong, that the covered list had things it shouldn't have on it, and then just sort of woodenly say, follow your course of action without speaking to what, as you point out, there are only a couple of entities on the covered list. So if the FCC had gotten that wrong, I think that the Secure Equipment Act would be a very strange statute indeed. So even if the text doesn't say, and specifically DAWA should be on there and Hikvision, I think that that's by far the more reasonable interpretation of what the FCC was supposed to do.
So you read it as not just ratifying, you read it as ratifying just the content of the list, or both the content of the list and the FCC's interpretation of the definition of communication equipment to include not what the statute says, essential to broadband services, but used in or used with broadband services. Do you think that was ratified too, that definition?
I think that's the better reading, but of course we don't, either of those possibilities offered by you would take care of this case.
So 2 years coming out with another company, brand new, nowhere on the list, comes along and the FCC says, aha, your product is used with broadband services. It's not essential to it, but it's used with it. And they challenge it and they go, what part of essential can't you understand? That's what Congress said, plain language. That's what they meant. All our usual rules of statutory interpretation, we read it, we got to apply it. And then your client comes along and says, oh no, Congress in this act here, which made no reference to our definition of covered equipment, and in fact, referred us back to the statutory definition of covered equipment. Congress signed off on essential being scratched out of the US code, and what we pencil in is stuff used with.
So again, I do want to get.
We would have to do.
No. So, well, well, okay. So the Secure Equipment Act, so I have several responses because it's a little bit of a long question. The Secure Equipment Act it's true, it lists the Secure Networks Act, but what it says is, I'm reading now from the Secure Equipment Act, section 2, the sort of 2A2. Commission shall clarify the commission will no longer approve or application for equipment or authorization for equipment that is on the covered list. So the list of covered communications equipment published by the commission under this section 2. Now, I think that the work of under section 2 is just clarifying what list we're talking about. As Judge Pan pointed out, it does, instead of saying equipment which is properly interpreted as or covered equipment or something of that nature, it just says on the list. What list are we talking about? We're talking about the list published pursuant to the Secure Networks Act. I think that's a fair reading of the statute. You asked about what happens in the future if somebody else makes video surveillance
Not
equipment.
video surveillance equipment. I'm not telling you what it is, but
Okay.
I'm telling you something that it is not remotely essential to the provision of broadband services. It is simply something that you plug into your computer.
Okay, so it wouldn't be on the covered list unless it met all of the prongs of the covered list. So I think a reasonable reading of the
Which prongs still apply
What?
after your reading of the SEA? Does it still have to fall within the statutory definition of covered equipment?
Yes, it must, but we
Okay,
find
so-
that this does.
Wait,
But-
I
Sorry,
really gotta
please.
understand this.
Absolutely.
And when they say the statutory definition is, and I think you can't dispute this, the statutory definition textually is essential to broadband services, correct?
Well, it says, it doesn't say essential to broadband services, it says essential to advanced communication.
Which is defined as broadband services and blah, blah, blah,
Well, but the blah, blah, blah is important. Yeah. Okay. So I'm now going to look at,
Essential to advanced communication services,
Video
which are high-speed
communication.
broadband telecommunications capability. High-speed switch broadband telecommunication. I wasn't leaving. I omitted the adjectives for time's sake, but I'll put them back in.
no,
Now they say we are not remotely essential to the provision of high-speed switch broadband telecommunications capability.
right, that is capability that enables users to originate and receive a number of things, including video telecommunications.
The capability. Yes, create
Right.
the
So I think it's,
things that use that power. This is the stuff that creates that.
so,
Using power and creating power, right? The electrical company creates the electricity in my house, right? That enables me to plug my microwave in.
mhm.
But that doesn't make my microwave a provider of electrical power, correct?
That's
Correct?
correct. That is correct.
And my microwave is not essential to the provision of electrical power just because I plug it into the outlet, correct?
That is correct.
Okay.
So,
They have equipment that they say we just sort of plug it in into whatever
right,
internet service you have, whatever internet service you have.
right.
And how is that essential?
So,
to the
so,
provision?
so one form of advanced communications is video telecommunications.
On this
and-
definition?
Sure, yes. So
How?
it's impossible to have video telecommunications without a video camera. It's possible to have lots of other kind of advanced telecommunications, but one form of that is a video camera. It is at a minimum reasonable to interpret the statute to include devices which make that.
Not entirely clear. and I don't have it in front of me, but the way it's stated is the broadband, et cetera, that's capable of doing X. And they're capable of your melding into the general definition. Broadband.
Right. I think I think it's true that this is subject to a number of different readings. But I guess what I would say is backing up a step. Congress has something in mind in the John.
Are you saying that everything?
Could you finish that answer?
Yeah. Okay. So Congress had something in mind. It was targeting some kinds of technology in the Secure Networks Act, which in turn cross-references the 2019 NDAA. So I think Congress was worried about these devices. Under petitioner's reading, it was worried about it maybe in the 2019 NDAA, but the Secure Networks Act was supposed to have a narrower scope, and it meant to carve those out. But it's a subtle mechanism that they're proposing, and I think a more reasonable reading of this statute of the Secure Networks Act is that Congress was concerned about this. That's why it cross-referenced the previous statute.
Just follow up on one of the things that troubled me about reading these briefs is I don't see any reference to any technical studies that indicate that any of this equipment that's at issue here has the capability of threatening the national security of the United States. And you said a number of times Congress was concerned. Congress was concerned that these were Trojan horses. But has anybody taken any of this equipment apart and seen whether there are any kind of bugs in there that could be used for nefarious purposes?
Oh, well, with the caveat that it wasn't necessary for the agency to reach that because it was relying on a determination of Congress. Just sort of as a matter of general interest or judicial notice, I point you to, we have a couple of footnotes or a footnote with some newspaper articles which study the petitioner's equipment in particular, Dahua and Hikvision, that these were subject to hacking, remote hacking. And also there's a commenter in this proceeding named IPVM, which is a security expert who submitted a lot of comments that this particular—
Who was it, IBM, did you say?
No, sorry, IPVM is the name of the commenter.
Oh.
We cite their comments in our brief if you want to follow that up. So there's some evidence of that, but I began by saying that that's not how these guys wound up on the covered list. Secure Networks Act referred to the previous statute and the FCC relied on that determination from Congress. If you had another entity going forward, maybe somebody that makes something which could be connected to the internet, then this capability prong of the statute would probably do a lot of work. And you'd have to say, well, is it capable of posing this kind of threat? But in this case, the agency's position was that determination had been made by Congress.
Got it. Thank you.
I just want to know what the statutory text is apply in that next case. I want to make sure I understand your position. So that next case, they're going to say we are not essential to the provision of high-speed switched broadband telecommunications capability that enables things. And your reading is that the definition of what's essential to the provision of high-speed, I just say broadband to save our time.
Sorry, the adjectives are not what's important.
Right.
My point was just that lumped in with that, it was video communications.
That's what it enables. And so your reading is that what is essential to the provision of power that enables activities is also the activities that are enabled? Because video equipment doesn't show up until the end as a list of things that is enabled, that you can do
Right. So
with broadband. I'm just trying to understand. So you read the enablement clause as also part of the definition of what counts?
I think that's a reasonable reading read
Is
in
that your reading? Is that the commission's reading? Because you keep saying it lists video telecommunications, but it only lists that as something that's enabled by the
right.
broadband telecommunications
Right.
capability.
So that is the commission's reading. So here's why I think the commission's view of the Secure Networks Act is in order to be communications equipment, we're going to have a broad definition. We're going to interpret essential to broadly, and the agency explains why. But that doesn't put you on the covered list. There's still this just sort of, you're in the basket of things which are eligible to be on
No,
the.
I'm just still trying to understand the plain English.
Mhm.
So you read everything that's enabled to be used by broadband telecommunications. That's everything.
Everything that, I'm sorry, can you say that one more time?
You're reading everything that, you're reading essential to the provision of high-speed switch broadband
Right.
telecommunications capability that enables, and then it lists users to originate and receive.
Right,
And list the things that users
Right.
originate and receive.
right.
You're saying what they originate and receive, which is anything anyone does on their broadband, on their internet, right? Anything that I use on the internet
Right.
at home is enabled by that internet.
Right.
Graphic, voice,
So devices which would make use of that capability and become part of the network in which allows that activity. But I would.
that makes those devices become essential to the provision of this capability. I'm just trying to make sure I understand this.
Right, so the essential comes from the Secure Networks Act, and then this capability is defined. This, as you, I'm sure know, this
Yes.
specific definition really served a different purpose originally in the 1996 Act, Communications Act. So that it is so essential to what? Essential to advanced communications is what Congress actually said in the Secure Networks Act, and then it cross-referenced another statute.
Okay.
And the agency said, well, what do we think is going on here? Why is it cross-referencing this other statute? And one clue that we have about what this means is these forms of equipment that are referenced in the 2019 NDAA. So I think, we often wish Congress had written things with more pellucid clarity, but here, I think it was clear that Congress was trying to get at something, and it was very reasonable for the FCC to say, whatever else is in this basket, it looks like they're concerned with video telecommunications, or excuse me, video surveillance equipment from Hikvision and Dahua.
That's a good question. Is there a procedure by which Hikvision and Dahua can contest their presence on the list other than what they've done here?
I think the remedy here is with Congress, because the way they wound up on this list was a determination made by Congress. So the
That's
FCC,
the only way. There's no way through the agency they can challenge.
I think so, because what the FCC has said is we don't have discretion to make further determinations about capability, et cetera, because Congress has made that determination. We do have a standing argument. I notice you've not asked questions about it, so I don't need to belabor it, but we think there's
Do you want to talk about?
yes, I was going to say I'm happy to talk about critical infrastructure. So as this court knows well, agencies can proceed incrementally. They can have a rulemaking and then follow up with further explication through adjudication. And that's pretty clearly what the FCC envisions happening here. It cross-referenced other expert government sources, the Patriot Act, and then two other executive agencies who deal with critical infrastructure all the time. And it said, this is what we think is critical infrastructure. And if you have any questions, please bring them to us.
Anything connected to?
Right, it did. It did. But all of that, if you look at paragraph 212. We don't know, but I think. No, we don't know yet. I mean, I think that's fair. Agencies can proceed that way. So what's happening now?
So do you have a meaningful definition that anyone can predict things under or not?
Yes. So it still has to satisfy the definition in the Patriot Act. So that's where.
You said anything can do the definition.
So I think read fairly, what the agency said is we're adopting the Patriot Act definition, which is, resources so critical that the impairment would be a threat to national security.
And then the agency said anything connected to that critical infrastructure will also be critical infrastructure.
Well, it said let's look at its paragraph 212. Or sorry, yeah, so paragraph 212. It's a JA 210. Okay, so it begins by saying, we are adopting the meaning provided by the Patriot Act. And then the agency goes on and references these two sources and says, for purposes of implementing the rules, we find that a system connected to these other sources could reasonably be considered critical infrastructure. But I think a fair reading, this still has to fit within the Patriot Act definition.
Sorry, you're in.
No, I jumped to the end of paragraph 212, which actually JA 211.
Next page.
Yes, the next page, exactly. The end of that paragraph. So I think all of this. Mhm,
Two
mhm.
could reasonably be considered critical infrastructure. So does that mean they are or they aren't? Or does that mean it's a free-for-all? You got to go through it everyone's got to adjudicate this one instance at a time before the agency?
Well, so I'd say two things. It always has to fit in this basket of the Patriot Act, right? So it still has to be a system.
No, you say that in addition,
Mhm.
things connected to
Well, I think a fair reading of this paragraph.
presidential directive and the
Mhm.
55 and the
Mhm.
critical
Mhm.
functions
Mhm.
could reasonably be considered critical infrastructure. Reasonably considered by whom?
What it says in paragraph 212, we delegate to these bureaus to develop further clarification.
I'm just asking you,
So
what is the point of the sentence if it does not sweep anything else? Does this sentence could reasonably consider critical infrastructure? Does this sweep anything in that's not covered by the Patriot Act or these two documents? Yes or no?
oh, you mean just the specific word connected sweep something in? So all it's connected to is these other two documents. So I think it's still the sources in those two documents.
So when you say connected to, well, it says, it's not, connected to is not a reference. It says connected to the 16 and the 55. So things that are connected to the list, the two.
Well, right. I think if you have a concrete example, when the agency has a concrete example in front of it, it can speak to this more clearly as for it's going to happen right now. So petitioners have these marketing plans. They have to explain how they're.
Is there anything that counts as connected to these critical infrastructure I'll just call them the list to say
Okay, sure.
the two lists. That isn't on those lists already.
I don't think so. Have you looked at you've probably looked at the list, right?
But I don't understand why you don't just stop and say we're doing the Patriot Act definition,
Mm-hmm.
as well as the things on these two lists. So you're telling me connected to the two lists just means on the two lists.
I have only what's in front of me, which is this paragraph, but I think that that's a fair reading of it.
No, the FCC's reading.
Well, all the FCC has said, of course, is what's in the paragraph, so I can't go beyond that. But I think that when this court is trying to decide whether the agency acted reasonably, and I think the question there is, was this a reasonable way to explicate the term critical infrastructure? And this court has said many times it's reasonable to proceed incrementally. It's reasonable to have a rulemaking and then elucidate through adjudication. So I would submit, I mean, the alternative might be to list every kind of business in America and have a checklist in or out, but that would be a very long list indeed. So this seems to be a reasonable way for the agency, which is a communications agency, not a national security agency, to proceed.
Yes, I just have one final question. So one way we could resolve this case is just to read the Secured Equipment Act as saying there should be no equipment authorizations for people on the list identified by this. These petitioners are on the list and the regulation implements that. And we would not have to read into the Secured Equipment Act any ratification of the process by which these petitioners got onto the list. We can just take the Secured Equipment Act at face value, can't we?
You can.
And then we wouldn't have to get into any of these other statutes and what they say and whether, like, who should really be on the list and who shouldn't, and what does all this mean?
I think that's a fair way to decide this case. The only thing I would say is if the agency got it wrong and misinterpreted the Secure Networks Act, this would be a strange course of behavior for Congress. So I think I submit to you the better reading is it, but you can write the decision.
What Congress was thinking about that
Sure.
process.
Sure.
And couldn't this just be resolved in a future case when somebody else gets put on the list and they want to litigate whether they should be there or not? That is when all of these statutory arguments would properly be considered.
I think that's an excellent way to decide this case.
Thank you. All right, we'll give you 2 minutes. Oh, I'm sorry. Sorry.
The supporting intervener.
Thank you, Your Honor. May it please the court, Tom Johnson appearing for Motorola Solutions. Often, Your Honors, in these administrative law cases, courts, even without explicit evidence, will apply a canon saying that Congress is presumed to be aware of the administrative interpretation of a statute. Here, we don't need to guess because Congress explicitly referenced the FCC's equipment authorization proceeding by docket number in the Secure Equipment Act, as well as the covered list, which applied only to those handful of entities that appeared on the NDAA. And in this sensitive national security area, in which this court frequently defers to the political judgments, the judgments of the political branches, it's an unusual case here where you actually have a Congress that is very responsive to what the FCC is doing and has shown time and time again that it is willing to enact new laws to cap in the FCC's discretion and ensure that the judgments of national security agencies are being taken into account and to tell the agency exactly how to do it. So this is not a process that is broken. And to address some of the questions that you raised, Judge Millett, in terms of the outer meaning of what essential might be or what covered communications equipment or services might be under this statute, at minimum, it has to be broad enough to encompass the subsection C determinations that Congress said the Commission must place on the covered list. And so if you just read the text of C3, which is the one that's at issue here, the communications equipment or service being covered telecommunications equipment or services, as defined in Section 889 F3 of the NDAA. And so we're looking for either what's the most reasonable reading of this statute, if you're going to defer to the FCC, or at minimum, what's the better reading of the statute. And it is by far better to presume that in such a prescriptive statute where the Commission is being given explicit instructions that Congress didn't intend to bury within a single word essential, some additional limitation on what might appear on the covered list, to raise all the problems you're discussing, Judge Millett, our routers in or out, our redundancies in the network in or out. In reply, they said, well, it's not an equipment specific.
There's also a problem with saying anything that's used with broadband counts as essential to the provision of broadband.
I don't think that's a problem, Your Honor.
Capability.
Again, looking for the better reading, I mean, this court has often said that the word necessary can't literally mean indispensable. That's just unworkable and would gut the statute. I mean, we cite in our brief examples of cases where
Here is essential, right?
the word's essential, and so that we're not aware.
Something that doesn't contribute at all to the provision of broadband service.
Well, we would disagree, Your Honor. First of all, we do think it's sort of a nesting doll where at minimum it encompasses the NDAA equipment based on the language of C3. But even if not, Your Honor, we do cite to authorities in our case, even the dictionaries that the petitioners cite that say essential doesn't need to mean literally indispensable. I mean, you talk about an essential question, an essential flaw.
Does it have to contribute in some way to the provision of broadband?
Yes, Your Honor, and I think that surveillance.
How does video equipment contribute in some way to the provision of this high-speed switched broadband telecommunications capability?
Sure, it is a capability that permits the end user to connect to a network.
No, that's what's created. The thing that it have to be essential to creating the capability. That's what the text is. You can't say the things that you can then do with it are essential to creating the capability.
Well, Your Honor, before we get to the more technical definitions, right, the very start of the phrase is essential to the provision of. So if, as I would submit, essential is broad enough to mean something like core, characteristic, of the nature of, important to, peripheral end user equipment fits that definition.
The provision of
because
what do they provide?
They provide a form of advanced communication services, which is video.
Okay, so
well, they, Your Honor.
The advanced communication service has a definition. I'm just not in this technical area at all. So their video equipment is a form of high-speed switch broadband telecommunications.
So, Your Honor, they're not providing broadband service. They're providing end user devices that connect to the network. And I agree, perhaps this could have been written more artfully, but it's clear that in the NDAA, video surveillance equipment is included.
If you
Then Judge
construe it
Pan's-
if you construe it the other way, then your argument is that means Congress made a mistake, not the FCC. It would be Congress that made the mistake.
That's exactly right, Your Honor. And Judge Pan made a similar point earlier, which is you would be looking at this single word to essentially eliminate from the covered list Hikvision equipment, DAWA equipment, because they say they are customer premises and user equipment, as well as ZTE. You asked a question about ZTE. ZTE is a cell phone manufacturer. There's evidence that the legislators were particularly concerned about ZTE. If cell phones produced by ZTE could not be on the covered list, that would be the implication if we read essential to only refer to core network equipment. And Judge Randolph, this sort of relates to a question you asked about what Congress was concerned about and how we would know. Counsel for the FCC mentioned the technical capabilities. But if you look at the NDAA, this section at the very end, after it lists these specific companies, there's a catch-all that says video surveillance equipment or services produced or provided by an entity, this is F3D, that the Secretary of Defense reasonably believes to be an entity owned or controlled by or otherwise connected to the government of a covered foreign country, which is China. And if you go back to the first supply chain order, again, there's been an iterative process, the very first supply chain.
Right. And would you give me the citation again to?
Absolutely, Your Honor. That is subsection F3D. I could try to find it in the appendix as well.
Oh, yes. Yeah. It's the critical energy.
So that's what Congress cared about, Your Honor. And in the first supply chain in order, there was both a public and confidential record talking about how Chinese state-controlled companies need to comply the espionage law in China to provide backdoor capabilities into equipment. All of these orders have been building on. And so Congress has made this determination, and that is why, Your Honor, that the more plausible reading of the statute is to say that anything with the capability to interact with the network has this potential. And again, that is sort of the judgment of Congress. I was going to respond to your question about future cases, Your Honor, if I have a minute.
Thank you very
Okay,
much.
thank you, Your Honor.
Now,
Thank you, Your Honors. Judge Randolph, you asked about whether anybody had considered what dangerous capabilities equipment at issue has. I'd just like to note that in paragraph 169 of the FCC's order, it specifically declined to even try to explain how this equipment had dangerous capabilities. And that contrasts very sharply.
Was there any history with respect to your client and the other company of any interactions with U.S. security that may have put Congress on the alert for this?
Your Honor, what happened was a representative, a member of the House, visited Fort Leonard Wood, was very concerned that they were using Hikvision cameras. Dawei makes very similar equipment. That's how the amendment got into the
I suppose that
NDAA.
if you were worried about it, as Congress apparently was, that it would be impossible to open up and inspect every single surveillance camera that went into a home or a business in the United States. How else could you regulate it except by barring it altogether?
Right, but remember that same act has the dangerous capabilities requirement in it. So somebody has to determine whether it has dangerous capabilities.
Yeah, got it.
And let me just say that this is in contrast to the Huawei and ZTE equipment. The bill as it entered into the House had detailed findings about Huawei and ZTE equipment. And of course, it didn't mention video surveillance cameras.
Not about your client.
And DOJ and various other federal agencies have issued reports about Huawei and ZTE, but nobody said that video surveillance cameras have the dangerous capabilities in the act.
Well, what do I do if I think it's a very close question? But the political branches, one reading of the statute is that the political branches have come together and said those on the covered list shall not have their equipment authorized, full stop.
Right.
Do we as a court need to defer to what is looks like this is national security, not our wheelhouse. And it seems like to rule for you, we would have to say, I think as Judge Pan suggested, that well, they didn't really mean what they seem to, at least the obvious consequence of what they've said. And instead, there's this sort of hyper-technical definition that we're supposed to go back and employ, even though Congress itself doesn't seem to be using it.
Well, I think the good task is to look at the text of the SNA, which has 3 requirements to be on the covered list. And I think your questions, I mean, essential doesn't mean used, and that's implausible. And you understand clearly that just something can be plugged in isn't essential to broadband. This equipment flunks the threshold test. Congress would want to change that, it can. But I think you have to read the statute, and Judge Pan, I think the easiest way to proceed is actually to address the threshold issue, determine that video surveillance equipment is simply not essential to the provision of broadband service, and that's all you need to decide. Let me note one other thing with respect to the Secure Equipment Act. And part of the reason why I think it's clear that it only applies to the consequences of being on the list, not the requirements for being on the list. In the NPRM that was referenced by Congress in the SEA, the FCC determined in paragraph 65 at JA 47 that it was not specifically authorized by the Secure Networks Act to deny certification to equipment on the covered list. And so Congress then stepped in and said, oh yes, you should deny certification to things on the covered list. That's the consequence. It said nothing about the requirements of being on the list. Thank you, Your Honors.
Okay. You wanted 1 minute?
Would like to address one point that Mr. Dunn made during his presentation, which was that he said the FCC is proceeding incrementally by adjudication to determine what critical infrastructure means. I would say that, even if the FCC had stopped with the Patriot Act definition and not added the additional commentary, there would still be borderline cases where adjudication would be necessary to determine what's critical infrastructure. The problem we have in this case is that the FCC has prescribed an unreasonable standard to be applied in those adjudications. And it has immediate effect because all DOTWA and Hikvision equipment, at least by the terms of the list that the FCC prescribed, is now covered equipment and is subject to various restrictions under the Secure Network Act, such as you can't use federal funds to purchase it. So we believe that this is an issue that's ripe for adjudication now.
Questions? Thank you very much. The case is submitted.